One guilty plea, one reduced bond, and one warning that could change everything. But just when it seems this defendant is getting a second chance, another case with murder, robbery, and serious charges takes center stage. Will these defendants walk away with probation, or are they heading toward much harsher consequences? Watch closely, because every decision made in this courtroom could change a life forever.
Good morning. Are you Donnie Smith?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Smith, in cause number 26, DCCR 0072, you're charged with a second-degree felony offense of assault on a peace officer from December 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any type of any right to appeal?
Yes, ma'am.
And so I see it's just marked off community supervision, but nothing
Oh,
else.
we're unagreed as to the type. The state is recommending straight probation. We're recommending deferred.
And leaving the type and the amount of time
Yes.
up to the court. So I want to make sure you understand that the agreement is that you get a probation. The type of probation, whether it's straight or deferred, will be up to me at sentencing, and also the length of time that you're on probation and any conditions and any fine in addition to that. Do you understand?
Yes, ma'am.
And you have an absolute right to have a jury come in and determine if you're guilty or not, and you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you have to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to a bond reduction based on that plea?
Judge, in reviewing Mr. Coleman's notes in this case, it doesn't appear that this young defendant has any substantial criminal history, just so the court is aware of pending UCW and evading also arose out of this incident. And so it's obviously concerning to the state that a weapon was involved. And if you've heard of what you think is appropriate, unless Mr. Coleman has additional to add.
Oh, nothing there to that. Thank you.
Thank you. All right, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond in your case to $2,000. If you make that bond, there's a couple of very important things that are going to go along with it. One, the very first thing you do is go straight to the probation department so they can start that process to get that report done for me. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be much worse. Do you understand?
Yes, ma'am.
Also, if you make that bond and you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting the agreement. You understand that as well.
Yes, ma'am.
In addition, I'm going to order as a condition of that bond, you are to have absolutely no possession of any firearm. Okay.
Ma'am.
That means you can't be in a car with someone else that has a gun. You cannot be in a home where there are guns. You cannot be around any guns until further sentencing. We'll figure that out depending on what's going on with that misdemeanor case.
Yes,
Do you understand? Any other conditions that?
No, Judge.
All right, then we will see you at sentencing. You can go back with the bailiff. Good morning, sir. You're John Jones.
Yes, ma'am.
And Mr. Jones has 4 cases, all on the set for trial to begin with jury selection next Monday afternoon. We have 25 DCCR 0523 charged with murder, 24 DCCR 2431 charged with unauthorized use of a vehicle, 25 DCCR 1352 charged with aggravated robbery, and 25 DCCR 1353 charged with robbery. And what is the announcement?
Judge, we're ready for trial. We just need to know which one is going first.
State's ready for trial, Judge. I believe we'll elect to try the murder first.
Okay. I will number the cases after docket today. Has there been any other discussions or negotiations? Let's see, was there an offer already rejected in the murder?
Yes, Your Honor, there was, and Mr. Coleman entertained some counteroffers that he wasn't willing to take. He did make a kind of a final offer last time, so I don't think we're going to get anywhere.
Okay. So it looks like the last thing I have, at least in writing, was 35 years.
That sounds right. I can bring my file down.
Okay.
That sounds right, Judge.
And so, Mr. Jones, I want to make sure you understand, your case will be set numbered, and those cases will be put in an order this afternoon after docket. And after today, there won't be any plea agreements unless there's some new information that comes to light. If you change your mind, you can plea either open to the court or some different amount that's negotiated. Do you understand?
Judge,
And
if I'm
you're-
not mistaken, I'm sorry to interrupt.
Go ahead.
I'm sure that the last setting the court acknowledged the defendant about the possibility of accumulation. I think at least a couple of these maybe.
Yeah, so it looks like we've got three different offense dates. It looks like the ag robbery and the robbery are the same date. And then we've got that unauthorized use from October of 24, and then the murder is from April of 25. What that means, and we've probably talked about it, but just in case we didn't, is that if you go to trial, so let's say you go to trial on the murder and the jury finds you guilty and you get some punishment, the state can then try aggravated robbery or the robbery. If you get a sentence on that, they can ask me to then stack those or run them consecutively. You understand that as well, right? Okay. And you want to go forward with your trial next week?
Yes, ma'am.
All right.
Judge, if you, I recall something now that I completely blanked out on. We had previously talked about doing a plea on the unauthorized use and just going the offer. I mean, the offer was two's the max, going open to the court because the state didn't want to piecemeal it. Just to get that one out of the way, Judge. If you want me to do the paperwork on that, I can.
Honestly, I think it's probably what I don't want to do, just based on the nature of that. I mean, all of those things, I guess, in punishment, whether convicted or not, could be used potentially as some types of extraneous offenses given the proper notice. I really am okay with you not doing that. Let's just keep them all together. Let's see where we get. If it goes forward next week, potentially, then we'll kind of go from there.
Address it from there.
Yeah.
Thank
Okay,
you, Judge.
thanks. All right. I'll let you know after docket the numbers for the order. Good morning. You're John Dre Willis. And so we were here before for sentencing. Mr. Willis had pled guilty to burglary of a habitation. There was a question about whether or not there was a murder charge pending or coming over in Calcasieu Parish. Charles? Lafayette. Sorry. And so what did you guys find out?
Okay. So I spoke with a detective out there. He referred to the prosecutor. Prosecutor said that there is a co-defendant. His case was sent to the grand jury. The grand jury, they don't call it no bill out there. I don't know what they call it. They no billed him on the murder, but they sent in a suggestion for manslaughter. So
On the co-defendant.
On the co-defendant.
Okay.
So the prosecutor told me that it's possible that Mr. Willis' case may go to the grand jury as a manslaughter, but he doesn't know yet. And he said they don't know until Mr. Willis gets to Louisiana. So there hasn't been anything filed on him.
Okay.
Judge, I left a message for same District Attorney Chris Landry on February 24th after we recessed from our last docket. I called back and spoke with his assistant who was going to give him another message. And I made multiple attempts yesterday to reach him. I wasn't able to reach anybody at that number where I had previously reached them. So I made every attempt I could to let him know. I filled in his paralegal about the situation we had and said, hey, heads up, if you guys want to hold or you need a 10-day marker or something, it'll be from next Tuesday, meaning today. So
Right.
those are the efforts I made. And I would suggest that out of fairness to the defendant, we if the court is inclined, we go along with the original plea of deferred.
Sure.
If they want to use it later, I'm happy to share my files information with them, but I don't think we should punish him with a conviction for something just because that may or may not be out there.
All right. I agree.
And also, Judge, I'm sorry.
Sure.
Just so that the court can recall, this is the one where the complainant went back and forth on wanting to prosecute. She did not. She came to court. She got a little jittery. She changed her mind. She waffled back and forth a few times, which was the reason for all.
Okay, thank you, Ms. Malvino. And thank you, Ms. Holmes, for making those calls as well. Okay, so what I'll do, Mr. Willis, today is go ahead and go forward with sentencing just the way this was all set up. If something happens when you get over to Lafayette and you're indicted or convicted, obviously we'll know where you are. If you, as soon as you're released, if they get a hold on you and take you straight from here, then when you are released, the first thing you need to do is contact our probation office.
Okay.
So whenever that is, all right. And if for some reason there's a conviction over there for something and you get some type of prison time, then you can write Ms. Holmes or get in touch with her or the court. And there's probably some ways that we can take care of this at the same time so that you're not doing some time and also on probation. Okay. But we'll deal with that when and if it happens. All right, so then in cause number 25, DCCR 1048, I'm going to find that you, and we've already gone over the pre-sentence report and everything. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity, especially if nothing comes out of whatever happened over in Lafayette, because you do not have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have the felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty. So you would become a convicted felon and you could be sent to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? And I'm assuming there is a no contact.
Richard.
What's the name?
Colette Richard.
Colette Richard. And so you're not to have any contact or communication with Colette Richard. And I understand that she's gone back and forth and y'all gone back and forth. But unless you have my permission, which could happen if you get out and you're on probation and you're doing well, and she probably takes an options class or something like that. If y'all are planning some type of relationship, you're not, so we don't have to talk about that. Then don't contact or communicate her. If she tries to contact or communicate with you, don't reply, okay? Because she won't go to prison, you will, right? All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir.
What do you think about the judge's decisions in these cases? Were the defendants given a fair opportunity, or were they shown too much leniency? Drop your thoughts in the comments below, we read every one of them. And if you're fascinated by real courtroom moments, legal drama, and life-changing verdicts, make sure to subscribe and turn on notifications so you never miss the next case that unfolds inside the courtroom.